So first things first, a power of attorney is a legal document that lets somebody give one or more people the power to make decisions for them. So when someone makes a power of attorney, they basically are appointing somebody else to act on their behalf. The person making the power of attorney is called the donor, and the person appointed to act on behalf is called the attorney. So there are two types. There's the property and financial, and then there's the health and welfare. If somebody wants to make a power of attorney, the person has to be capable of making decisions for themselves. That's called mental capacity. And we'll go on to that a bit more later on. So you might be wondering when you may need to think about considering securing a power of attorney. It's really important to have this in place as soon as possible. And the reason for this is because it can become more difficult and expensive when somebody has lost their capacity. Without a lasting power of attorney, if somebody needs another person to step in and manage their finances in the future, their only option at that stage would be to apply for what is called a deputyship through the court. And that is quite costly, it's lengthy, and can be quite complex. If somebody becomes unable to express their wishes, the lasting power of attorney enables someone to step in and make those decisions for them. And nowadays, hospitals and GPs and all those services, they're becoming a lot more stricter in this with the lasting power of attorney is in place. I think since COVID, we know that life is uncertain, and so it's important to get these documents completed in advance. And also because it can take between 8 and 10 weeks to register a lasting power of attorney. Once it's in place, the person should hopefully have some sort of peace of mind that somebody that they trust can look after their affairs for them. And now this is quite a difficult topic, I can appreciate, to bring up with your family or the people that you provide care for. And so maybe explaining the advantages to them will be helpful in trying to navigate any concerns that they might have. So speaking about it in a known and comfortable environment that the person knows will help them be at ease. That might be in their own home. It might be in their town centre or over a cup of tea, something that brings them comfort. You can ask them what concerns that they might have about getting a power of attorney and explain that you can seek advice on the concerns, and you're welcome to approach us here at Carers UK. You can explain that they have the choice in choosing who they want involved in decisions for them. So ultimately they have choice and control over that. So there are different types of power of attorney. There's a general or continuing power, and that gives the attorney the authority to make decisions or take actions about your finances while they still have capacity. And that's also called an ordinary power of attorney. There's the lasting power of attorney for property and financial affairs. That gives the attorney the authority to make decisions about their finances with your permission, or if you lose mental capacity. There's the health and welfare side of the LPA, which gives the attorney the authority to make decisions about your health and care if you lose mental capacity. Then there's one called the enduring power of attorney that was replaced by the lasting power of attorney for property and financial affairs on the 1st of October. But if one was made before that, it's still valid. So I'll just talk a bit more about each one of those. So the general power of attorney, you can set that up if you need someone to make financial decisions on your behalf. It's only valid whilst you still have mental capacity to make your own decisions. And it may need to be set up if you may want somebody to act for you for just a temporary period, for example, when they're on holiday or in hospital. It may be that you're finding it harder to get out and about to the bank or post office, or you want someone to access your account for you. You want somebody to act for you whilst you're able to supervise their actions. So this type of attorney is only valid whilst you have mental capacity to make your own decisions. If you want somebody to act on your behalf, And if there comes a time where you do not have capacity to make your decisions, then it's important to set up the lasting power of attorney instead. So this type of attorney is only used by individuals who are able to conduct their own affairs, but like I said, where for practical reasons they need somebody to act on their behalf. It can be effective for a specified time, like the examples that I gave on the previous slide, or it can run indefinitely until the donor decides to bring it to an end. And when you want to bring it to an end, it's called a deed of revocation. So the lasting power of attorney, which is a different type, this is a way of giving somebody that you trust, which is your attorney, the authority, the legal authority to make decisions on your behalf if you lose mental capacity to do so in the future, or if you no longer want to make decisions for yourself. There are two types. There's the financial, and then there's the health and care one. For the financial decisions, it can cover things such as buying and selling property, paying the mortgage, investing money, paying bills, or arranging repairs to the property. An LPA for financial decisions, it can be used whilst you still have mental capacity, or you can state that you only want it to come into effect if you lose capacity. So you have that choice to say when it comes into effect for you. If the LPA for financial decisions is set up, the attorney has to keep accounts and make sure that their money is kept separate from yours. The LPA for health and care, that can only be used once you have lost mental capacity. An attorney for health and care can make decisions such as where you should live, your medical care, what you should eat, who you should have contact with, and what kind of social activities you take part in. That's just some examples. It's not the complete list. The enduring power of attorney is a document that appoints an attorney to help manage your property, money, and affairs. It was replaced with the Property and Financial Affairs LPA in 2007, but like I said earlier, if it was set up before 2007, you can still continue to use it, or if you want to, you can cancel it and set up the Property and Financial Affairs one. So to apply for this, you can do this online, or you can do it by using paper forms. You can contact the Office of Public Guardian, and I've just put the email and phone number here for you. So if you want to, you can get in touch with them. So there is a cost with it, but there are exemptions, which I'll talk about later. You'll need to register before you can use it. And in England and Wales, the registration fee is £82 for each LPA. So it costs £164 to register both. You may be exempt from paying the fee if you're on a low income or if you receive certain income-related benefits. So, like I mentioned, there are concessions and exemptions. If the donor receives any of the following means-tested benefits, they can apply for the exemption. So that's income support, income-based ESA, income-based job seekers allowance, guaranteed credit element of state pension credit, housing benefit, council tax reduction, local housing allowance, and a combination of working tax credit, and at least one of the other tax credits which are listed here. If you want to apply for an exemption, the form is the LPA 120A, and you can find that on just by typing it into Google and going onto the government website. That has to be sent with the LPA or EPA forms, as well as any evidence that they ask for. So a donor can also qualify for remission if they're in receipt of universal credit. Evidence will need to be provided that the donor receives universal credit, and copies of letters which show the entitlement will also need to be provided. And so that might be your online bank statements or a letter from the DWP. It's important that the letter includes the name, address, and postcode as well. If the donor's gross annual income is less than £12,000, they may be eligible for a 50% reduction of the fee, and that's the gross annual income is before tax. So income might be from employment or benefits, and I've just listed that, or savings or investments and rent, etc. So when you're applying for remission, you need to be providing supporting evidence. So the evidence you provide must relate to the time you send the application to register. So bank statements won't be accepted for that. The evidence can be paid employment, non-means vested benefit, an official letter, any interest that you have, like stocks and shares, or self-employment, your recent tax return. If the donor receives no income, then they have to send a signed statement explaining how they support themselves. If they don't have mental capacity, then their attorney or solicitor, if they have one, can supply and sign that statement for them. So if the Office of Public Guardian come back and they refuse the exemption or remission, you can challenge it. You can appeal within 4 weeks of the decision by writing to the head of corporate services. If it's the original decision is upheld, it will then be referred to the public guardian. If you are appealing, it's really important to argue the points which are in dispute. So have a look at the letter of rejection and focus on why they're refusing it, and provide answers to those particular points. And where evidence you can provide, then provide that where possible. It's important to be completely transparent about your financial circumstances and how you meet the eligibility criteria for the exemption or remission that you're applying for. If the donor doesn't qualify for remission or exemption, but paying the fees would cause hardship. For example, if you had to pay for these fees, it would mean that you can't meet normal living costs, such as buying food, paying bills, then you can apply to have the fees waived. To claim this, you have to write to the Office of Public Guardian explaining why payment would cause hardship, and enclose your bank statements and other documents such as your savings, income and outgoings. And so you might be thinking, well, how can I explain hardship? Because there's quite a lot of people who are facing hardship, especially with the cost of living crisis and things like that. So you can explain what your normal living costs are. Do you have to keep the heating on more than usual? So do you have higher bills because the person you provide care for is sensitive to cold? Do you have to use more water than usual? So is the person that you're providing care for needs to have more showers? Do you have to put more washing on, and that sort of thing. Set out what the disability related expenses are for the person and explain why those costs are necessary. So disability related expenses are any expenses that a person has that are related to their disability and which are not met by the NHS or social services. If on a low income and if supporting the family, explain this and state what you're left with after paying bills and rent and things like that at the end of each month. If necessary, you can provide an income and expenditure sheet. I know that there are plenty of examples on Google where you can download it and use it as a template. It might be that you're paying carers on a private basis. If so, then also state that as well. Just have a think about your own circumstances and what you have to pay for. If a power of attorney is not set up, if someone loses mental capacity in the future and a power of attorney is not set up, the Court of Protection will can appoint a deputy to make decisions for them. Someone who wants to make decisions for another who has less capacity can apply to the court protection for a deputy, become a deputy. So it's a different process to what we're talking about here. But the role of a deputy is very similar to that of an attorney. They're just called different things. So when you go through this process, you're going to come across these words quite a lot, which is acting in someone's best interest. An attorney has to always make decisions that is in the person's best interest. This means that they have to do everything possible to enable them to express your preferences, consider past and present feelings, consider any beliefs and values, talk to other people such as close family friends who may know about the feelings and beliefs and values, and respect their right to privacy at all times. And also another word, two few words that you're going to come across a lot if you're going through this process is mental capacity. Mental capacity is basically the ability to make or communicate specific decisions at the time that they need to be made. And to have mental capacity, you have to understand the decisions that you need to make, why you need to make it, and the likely outcome of your decision. Now, some people will be able to make some decisions about some things, but not others. So when someone is looking at your capacity to make a decision, they have to ask 3 questions, which is, I have to ask these questions. Can you understand the information related to the decision? Can you remember the information for long enough to make that decision? Can you weigh up or use the information to reach a decision? And can you communicate it in any way at all? People cannot assume that you lack capacity because of your age, appearance, or any mental health diagnosis you have, or any other disability or medical condition. So that we do come across situations where people have concerns about their attorney, and there is things that you in place that you can do if you have concerns. If they have concerns that the attorney is not acting in the best interest, you can contact the Office of Public Guardian. You can either report the concern on the report concerning form or write to, email, or call the OPG. And I've just put the website here where you can find out a bit more about that. The link that I provided also provides details of the safeguarding email address and contact number, as well as their postal address. So what the OPG will do is they'll investigate allegations of mistreatment or fraud, and when necessary, they can report concerns to the police or social services, especially if a criminal offence has taken place, then the police will be involved. If there are concerns you have about abuse or neglect from the attorney, then the local authority safeguarding team should be contacted. And this is a lot about where somebody else is an attorney and you're viewing it as an outsider. So it might be somebody else acting as an attorney for the person that you provide care for. If there are concerns about somebody living in a care home, then the Care Quality Commission can also be contacted. So your concerns might be various, but the ones that we come across a lot are misuse of money or decisions that are not in the best interest of the person that they're responsible for. So when you're writing this report, you have to include the following information, which are donors' details, the date you first noticed the concern, any evidence you have to support the concern, what you know about the donor's mental capacity, and your own contact details. If somebody is in immediate danger, or if you think somebody has committed a criminal offence, then call the police or 999, whichever is more appropriate at the time. If the donor would like to remove an attorney from an LPA, they can do this by completing what is called a deed of revocation. And I put the link here for you to have a look at later on. You will get these slides, I believe, So I think today or tomorrow. The revocation must also be sent to the OPG along with the original LPA document, and the donor should also notify the attorneys as well. The donor may also want to inform other people, such as the bank, building society, or GP, about this. If attorneys are appointed jointly, because you can appoint one or more, then a partial deed will cancel the LPA. Joint attorneys are appointed as a unit, so to remove an attorney will stop that unit from functioning, making the LPA unusable. If the attorneys are appointed jointly for some decisions, jointly and severally for other decisions, then the decisions to be made jointly can no longer be made. Again, this is mainly because the joint unit has been broken. And so this partial deed of revocation cannot be used to enable a replacement attorney. It's not possible to add an attorney to an existing LPA. If the donor would like to add an attorney at this point, they'll need to submit a new LPA application with the registration fee. And the donor has to be deemed to have mental capacity to complete a new LPA at that time. So we often get asked questions as in, do I need a solicitor to apply for these forms? You don't actually have to use a solicitor to create an LPA. The application forms are on from the Office of Public Guardian, contain really useful guidance to help you fill them out. You can fill them online or phone the OPG helpline if you have any issues or concerns. If you do decide to use a solicitor, then you do have to pay them to complete the forms for you. And fees for this type of service can vary. So you may want to contact a few law firms to compare their fees and the service that they might offer you. You can search for a solicitor that specialises in this type of work by contacting the Law Society website, and most high street firms do this type of work. You can also connect with local carer groups and services to see whether they know of any recommended law firms in the area. You might want to go with a firm that is recommended rather than, searching and spending hours trying to find a good firm. So you can maybe reach out to local carer groups and see what's in the area. And so you can use our online directory for that. So I'll just talk a little bit about Scotland and Northern Ireland, if we have any people that are in the group today from there. So there are different types of power of attorney in Scotland. There's the continuing power of attorney that enables someone or more than one person to look after your property and financial affairs. You can choose whether a continuing power of attorney takes effect straight away or only comes into effect if you lose capacity later on. There's the welfare power of attorney, and that enables someone or more than one person to make decisions about your health and welfare only if you're unable to do this yourself. And then there's the combined continuing and welfare power of attorney that enables someone or more than one person to look after both your financial affairs and your health and welfare decisions. There's also something called the simple power of attorney, and that is created for a set period of time or for a specific issue. A simple power of attorney can only be used whilst you have mental capacity to make your own decisions, and it doesn't have to be registered. So it's very similar to in England, where you have the general or ordinary power of attorney. So similarly to England, if you lose capacity to make decisions for yourself and you've not appointed an attorney, somebody will have to go to court to apply for what's called a guardianship order. So to be valid, the power of attorney needs to be registered with the OPG in Scotland, and they aim to process applications within 30 days, but it can take longer in busy periods. So in Northern Ireland, the definition is very similar to England and Scotland and Wales, in that it's the power of attorney is given to somebody to make decisions on your behalf. It ceases when you become mentally incapable of managing your affairs, but the enduring power of attorney will continue. So it's a little bit different in Northern Ireland. To become effective, all enduring power of attorneys need to be registered with the High Court, which is the Office of Care and Protection. But registration is not required until the point where your attorney believes they're no longer capable of managing their affairs. And so they've got general guidance here for you if you need to have a look at that, if there's anyone from Northern Ireland here today. So I've just put some really useful signposting information for you here. There's the Age UK, who are really helpful with citizens' advice. Hourglass, which is a national organisation that provides a helpline for anyone who's concerned about abuse of older people in care homes or in their own homes. And then there's Solicitors for the Elderly. It's an independent organisation of various solicitors who specialise in a range of legal issues that affect older people.